Payments to former college athletes were supposed to start up next month after a federal judge approved the House versus NCAA settlement just last week. But now those payments are on pause. KREM 2's Caitlin Galloway joining us now to explain why. Caitlin?
Thanks, Mark. Yeah, the reason is because an appeal was filed yesterday by a group of 8 women athletes on the basis of Title IX, specifically regarding back pay given to former athletes. I spoke with the attorneys on both sides of this case about what happens next. Jeffrey Kessler has been working on the House versus NCAA settlement from the beginning, representing the athletes. He had a simple answer about how Title IX applies in this case.
It doesn't.
Ashlyn Hare represents a group of 8 women athletes, claiming the revenue model used to determine back pay discriminates against women's sports.
The way that the damages were calculated, which is 90% going to football and men's basketball, never would have been allowed under Title IX because those payments would have been coming directly from the conferences and the schools.
Hare's specialty is in Title IX and athletics law and says Title IX has 3 prongs: equality in participation opportunities, financial aid, and equal benefits. The settlement could fall under either of the last 2. Meanwhile, Kessler has a history of successful antitrust cases, especially in sports. He won a case in the 90s establishing free agency in the NFL. He feels the issues are valid but not relevant to this case and says he's disappointed it now holds up damages athletes fought so hard for.
Frankly, this is a frivolous appeal, and it only has the effect of punishing over 100,000 athletes who are waiting for their damages.
The major deciding factor: does Title IX apply to a damage settlement? Ordinarily not.
The damages in this case are simply, given what the revenues were of the different sports, how would the compensation have been divided between the athletes in a competitive market which follows the revenues.
But this one involves the NCAA.
You have to account for what they would have been paid in the but-for world. How much would people have been paid if there weren't this unlawful restraint on earnings? And essentially, we're saying there's a federal anti-discrimination statute in place that would have been in place at the time that these damages would have been paid out. And there's no reason to ignore that in the antitrust setting.
Hare told me there's no timeline for sure yet. Appeals in federal court move notoriously slow. They'll combine all of the appeals as they anticipate more and progress from there into oral arguments.
All right, Caitlin, you've been digging into this appeal since it was filed just yesterday. Was anybody expecting appeals or lawsuits in response to the settlement?
So I talked with the Cougar Collective and they said, I think the answer is yes, but maybe not yet. They were expecting more lawsuits around the formula to determine market value for an athlete, where they'd look at recruiting status, position they played, social media followers, things like that, to determine if outside NIL deals, like third-party NIL deals, were at market value for the athlete.
Yeah.
Maybe not at this point yet in the settlement.
Cougar Collective, by the way, kind of raises NIL money for local athletes at WSU, right?
Yes, that's correct. Yep.
So the next question quickly is, what's this mean for local athletes?
Yeah, absolutely. I mean, there are a couple athletes at Washington State that were expected to benefit from these back pay payments that are now paused. The other thing is schools were expected to follow that general formula for being able to pay current athletes, and that raises interesting questions for, one, will they stick with that model moving forward now that this is in place, but also schools like Gonzaga that don't have a football program could be in a really interesting situation too.
All right, keep us posted, Caitlin. Thank you very much.
Thanks so much.